California is committed to rebuilding communities affected by wildfires and supporting employers and employees engaged in the rebuilding efforts, including those persons who work on public works projects. To that end, we present this overview of California labor law for public works contractors. Topics to be covered in this presentation are California prevailing wage laws, worker rights in emergencies, and the Immigrant Worker Protection Act.
Let's start with California prevailing wage laws. California prevailing wage laws require the payment of prevailing wages to anyone working on public works projects and compliance with other requirements as well. To understand when California prevailing wage laws are applicable, we will go over some definitions. Public works refers to construction, alteration, demolition, installation or repair work done under contract, and paid for in whole or in part out of public funds. Public works also includes the hauling of refuse from a public work site to an outside disposal location. The hauling of refuse includes hauling soil, sand, gravel, rocks, concrete, asphalt, excavation materials, and construction debris. Public works can include pre-construction activities, such as inspection and land surveying, and post-construction activities, such as cleanup work related to a public works project. Public works can also include maintenance. Maintenance in the context of public works in California means routine, recurring, and usual work for the preservation, protection, and keeping of any publicly owned or operated facility. Carpentry, electrical, plumbing, glazing, and other craft work designed to preserve the publicly owned or operated facility, and landscape maintenance. An awarding body is the entity that awards the contract for public works. The awarding body can be a public entity, such as the state, or a political subdivision of the state. A political subdivision of the state includes any county, city, district, public housing authority, or public agency of the state. The awarding body can also be a private entity using public funds.
Paid for in whole or in part out of public funds means payment of money or the equivalent of money by the state or political subdivision directly to or on behalf of the public works contractor, subcontractor, or developer. Performance and construction work by the state or political subdivision in the execution of the project. The transfer by the state or political subdivision of an asset of value for less than fair market price. Paid for in whole or in part out of public funds also means fees, costs, rents, insurance or bond premiums, loans, interest rates or other obligations that would normally be required in the execution of the contract that are paid, reduced, charged at less than fair market value, waived or forgiven by the state or political subdivision. Money loaned by the state or political subdivision that is to be repaid on a contingent basis. Credits that are applied by the state or political subdivision against repayment obligations to the state or political subdivision.
What if a project is federally funded?
If a project is federally funded, plus the project is controlled or carried out by a state or political subdivision of the state, then California's prevailing wage requirements apply. However, if a project is federally funded and there is complete federal control over the project, then California's prevailing wage requirements would not apply.
A public works contractor is anyone who bids on or enters a contract to perform work that requires the payment of prevailing wages. Public works contractor also includes a subcontractor who has entered into a contract with another contractor to perform a portion of the work on a public works project. It includes sole proprietors and brokers who are responsible for performing work on a public works project, even if they do not have employees or will not use their own employees to perform work. Now let's talk about the requirements for public works contractors. Generally, there are 5 areas for compliance. As for the first, contractors must be registered with the DIR to bid, be listed on a bid, be awarded or perform on a public works project. Higher-tiered contractors must ensure that any lower-tiered contractor who they hire or contract with are also registered. The registration requirement does not apply to projects of a total contract cost of $25,000 or less when the project is for construction, alteration, demolition, installation, or repair work, or when the total contract cost is $15,000 or less when the project is for maintenance work.
The second requirement is the Public Works Contractor must pay the prevailing wage rates to all workers. Labor Code Section 1774 provides that the contractor to whom the contract is awarded and any subcontractor under him shall pay not less than the specified prevailing wage rate to all workers employed in the execution of the contract. The exception is for public work projects of $1,000 or less. The Director of DIR determines the general prevailing wage rate for per diem wages according to the craft classification or type of worker and by location. The prevailing wage rate determinations are available on the DIR website. The prevailing wage determinations are generally issued twice a year, on February 22nd and August 22nd. The effective date is 10 days after the issue date of the determinations. The awarding bodies and contractors use the bid advertisement date of the project to determine which prevailing wage rates apply to the contracts. The determination reflects the basic hourly rate plus the fringes to be paid and the total hourly wage rate. Prevailing wage law requires the payment of overtime, which is 1.5 times the basic rate of pay, to be paid for all hours worked in excess of 8 hours daily and 40 hours weekly. Additionally, overtime may be required at a higher rate than 1.5 times the basic rate of pay, for less than 8 hours daily or for less than 40 hours in a work week, as specified on the prevailing wage determination. The determination will also reflect Saturday overtime rates and the Sunday holiday overtime rates. When paying workers employed on a public works project, the contractor must be aware of the requirements to pay the basic wage rate, fringe benefits, overtime, holiday overtime, travel, plus subsistence and predetermined increases to rates, if any. The determination and supplemental provisions include all of this information. Visit the DIR website for prevailing wage determinations and related information.
The third requirement for public works contractors is to comply with apprenticeship requirements. Contractors working on public works projects valued at $30,000 or more have an obligation to hire apprentices. With few exceptions, this duty applies to all contractors and subcontractors on a project, even if their part of the project is valued at less than $30,000. Contractors must submit contract award information, or Form DAS 140, for each craft to all authorized apprenticeship programs that can supply apprentices in the geographic area of the public works project before beginning work. Contractors must also submit a DAS 142 form to the applicable apprenticeship committees to request dispatch of apprentices. This form must be submitted at least 3 business days or 72 hours before apprentices are required. The public works contractor must employ apprentices in the correct ratio. The minimum apprentice to journey worker ratio is 1 hour of apprenticeship work for every 5 hours of journey worker work. Only straight time hours are included in the ratio calculation, not overtime. This requirement is on a per craft basis. The public works contractor must also make training fund contributions in the amount established in the prevailing wage determinations, either to the applicable apprenticeship committee or the California Apprenticeship Council. Visit the DIR website for more information on apprenticeship requirements.
The fourth requirement is to maintain and furnish payroll records. Labor Code Section 1776 provides specifically that each contractor and subcontractor shall keep accurate payroll records. There is a form called the DLSE Form A131 that may be used. This form contains spaces for all the required information. See Labor Code Section 1776 for what information is required on payroll records. The fifth requirement is for contractors to furnish electronic certified payroll records, or eCPRs, directly to the Labor Commissioner. The eCPR requirement does not apply to projects of $25,000 or less when the project is for construction, alteration, demolition, installation or repair work, or for projects of $15,000 or less when the project is for maintenance work. However, the contractor is required to retain records for at least 3 years after the completion of the work.
Our next topic is workers' rights in emergencies, set forth in Labor Code Section 1139. Workers have special rights during emergency conditions. Emergency condition means conditions of disaster or extreme peril to the safety of persons or property at the workplace or work site caused by natural forces or a criminal act, or in order to evacuate a workplace, a work site, worker's home, or the school of a worker's child due to a natural disaster or criminal act. In the event of an emergency condition, an employer shall not take or threaten adverse action against any employee for refusing to report to or leaving a workplace or work site within the affected area because the employee has a reasonable belief that the workplace or work site is unsafe. This does not apply to first responders, disaster workers, and others. See Section 1139, Subdivision B1 for all persons to whom this does not apply. Employers shall not prevent any employee from accessing the employee's mobile device or other communication device for seeking emergency assistance, assessing the safety of their situation, or communicating with a person to verify their safety. This applies to private, state, or political subdivisions of the state. This does not apply to employees of a depository institution or an employee of any correctional facility. When feasible, an employee shall provide notice to the employer of the emergency conditions requiring the employee to leave or refusing to report to work. These protections continue until the emergency ends.
Our next topic is the Immigrant Worker Protection Act. The Immigrant Worker Protection Act, effective January 1st, 2018, expressly steers clear of federal law with the use of the phrase, "except as provided by federal law." The Act added Government Code Section 7285.1, 7285.2, 7285.3, and Labor Code Sections 90.2 and 1019.2. The Act is enforced exclusively by the California Attorney General and the Labor Commissioner. It applies to private and public employers. Under California's labor law, employers are prohibited from requesting more or different work authorization documents than required by federal law, misusing the E-Verify employment verification system, threatening to file a false report with any government agency, threatening to contact or contacting immigration authorities. In addition, employers are legally required to comply with notice provisions informing employees of I-9 employment verification audits at the workplace, and notifying their authorized representative of the activity and outcome. Next, we will discuss each Government Code section in more detail. Government Code Section 7285.1 prohibits an employer or a person acting on behalf of the employer from providing voluntary consent to the entry of an immigration enforcement agent to any non-public area of a place of labor. This section does not apply if the immigration enforcement agent provides a valid judicial warrant. An example of providing voluntary consent to enter a non-public area could be freely asking or inviting an immigration enforcement agent to enter that area. This law does not require physically blocking or physically interfering with the entry of an immigration enforcement agent in order to show that voluntary consent was not provided. Employers are not precluded from taking an agent to a non-public area if employees are not present in the non-public area, and the agent is taken to the non-public area for the purpose of verifying whether the agent has a judicial warrant, and no consent to search the non-public area is given in the process. Government Code Section 7285.1 does not define the meaning of non-public, nor otherwise indicates that the term non-public should be given anything but its usual or ordinary meaning. A non-public area is one where the general public is not normally free to enter or access, such as an area where payroll, personnel, or client records are kept. Government Code Section 7285.2 prohibits an employer or persons acting on behalf of the employer from providing voluntary consent to an immigration enforcement agent to access, review, or obtain an employer's employee records without subpoena or judicial warrant. This does not apply to I-9 employment eligibility verification forms and other documents for which a notice of inspection has been provided to the employer. Government Code Section 7285.3 provides In accordance with state and federal law, nothing in this chapter shall be interpreted, construed, or applied to restrict or limit an employer's compliance with a memorandum of understanding governing the use of the federal E-Verify system. Labor Code Section 90.2 requires that, within 72 hours of receiving a notice of inspection of I-9 forms or other employment records by an immigration agency, an employer must provide notice of inspection to each current employee and to the employer's exclusive collective bargaining representative, if any. This notice of inspection must be in the language typically used to communicate with the employees. See Labor Code Section 90.2 for what information is needed in the notice. Within 72 hours of receiving written notice from the immigration agency of the results of the inspection of the I-9 forms or other employment records, an employer must also provide to each current affected employee and to the employee's exclusive collective bargaining representative a copy of the written notice from the immigration agency that provides the results of the inspection of the I-9 forms and written notice of the obligations of the employer and of the affected employee arising from the inspection. Labor Code Section 1019.2 provides that, except as otherwise required by federal law, a public or private employer, or a person acting on behalf of a public or private employer, shall not re-verify the employment eligibility of a current employee at a time or in a manner not required by Section 1324A(b) of Title 8 of the United States Code. The Labor Commissioner established a business engagement program to provide training to employers regarding legal obligations. Email makeitfair@dir.ca.gov to request a training, ask a question, or report a competitor who is gaining an unfair advantage by violating California law. For more information on these topics, please visit the DIR website.